I will note that Mr. Perez Beal appears, along with his attorney of record, Ronald Wood. Sydney Simon appears separately from her attorney of record, Lauren Schuler. This matter comes before the court at this time for further proceedings. Counsel, this court had conducted a trial in this case, made rulings and orders which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuler and ask her, where are we at on this case?
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections that are appropriate.
I did make them.
Okay.
So specifically, objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to go over my objection to the motion if you would prefer that.
Buckle up, guys. Today we're diving into one wild courtroom showdown. A male Karen thinks he can outsmart the system, firing his lawyer and taking on the judge himself. The tone is set fast. Confidence meets arrogance. And you can already feel this isn't going to end well. It's the calm before the chaos. And the judge? He's not here for games. Let's see how this drama unfolds.
All right, Mr. Wood, as far as the court's concerned, the court wants to settle this journal entry before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those at the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could. And then once I did that, then I received wording from my client that he was did not approve of what I have objected to and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd start sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. The journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to the disciplinary administrator, that concerns me that I've got someone, watching over my shoulder. He doesn't trust my abilities to do the work that I'm doing, doesn't understand with 46 years of experience that I know what I'm doing.
All right, guys, here's where the tension starts to crackle. The judge lays it out clearly. No lawyer walks away until the messy journal entry is sorted. But the attorney's face says it all. He's done babysitting this client. The courtroom suddenly feels smaller as professional patience meets personal frustration. You can almost sense the judge's silent thought. This case is about to spiral.
If he and I cannot communicate, if he continues to think that I'm not doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooler, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections are, or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after the our Exhibit D, the email including me and Mr. Wood with the disciplinary administrator, where Mr. Presbeal says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine, is there a legitimate objection to the wording used by Ms. Schooler in what I see as, and I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor. All
right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then that's not objectionable.
May I make a statement?
Mr. Presbeal?
Yes, sir. That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administer, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay,
exchanges
we're getting
of
off the
court
path
order
here.
twice.
We're
No,
getting,
sir, we're not.
okay. All right, regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause and some reason to make a finding that the court has concern that Mr. Perez-Beal will not respect the bond of this child with his mother.
That was during my
And there are other
parenting
reasons. However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez-Beal may deny that there was ever any abuse by him, court does find that that's an appropriate finding for the court to make. And the court will
Point of
overrule the
order.
objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does
I'm
find that there's
submitting all of
evidence
our
in the
text
record.
messages.
All right, if you interrupt one more time, Mr. Perez-Beal, we're going to mute you or take you out of the meeting completely.
Yes, sir.
This is where things explode. The attorney, after 46 years of service, loses composure and fires back with that iconic jab. 46 years of experience trumps 46 minutes of Google Law School. The sarcasm cuts through the courtroom. It's the perfect snapshot of a veteran lawyer crushed by online know-it-all arrogance. You can practically hear the judge suppressing a sigh, knowing the circus has only just begun.
You can object all you want, but if the court determines that it can settle the journal entry today, it will.
This is
We
a
can't
hearing
just
for
hold up-
withdrawal.
We can't just hold up this decree indefinitely because you object to some of the rulings that the court made.
That's why I
trying to do
have requested
is-
it.
just
That's
a
why
minute,
I'm
just a
getting the
minute. What
transcript.
we're trying to do today is properly document the court's rulings. You can disagree with those, Mr. Perez-Beal.
Because that's what
You may even
the
be able
court-
to take further legal action concerning them, but at this
Also-
juncture, we're just trying to settle the journal entry.
When it comes to on the journal entry,
All right.
Miss
the child
Shore
support
used a
worksheet.
fraudulent witness.
I'm going to tentatively adopt the language in the proposed decree because it is being represented by preparing counsel that she has properly used the numbers that the court ruled upon at the time of the hearing to formulate a worksheet. But without that worksheet before it, this court will reserve an eventual ruling until I see that worksheet as submitted in my queue with the decree. So, Ms. Schooler, it has to be with it.
Absolutely. I apologize. I just wasn't a legal objection, so I just didn't think, I thought we were going to resolve only that. So it will be submitted, of course.
Very well. So I'm going to overrule the general objection in number 8, purporting that I adopted some prior worksheet.
And Your Honor, I can read you my specific notes to you as to the income if you'd like to. Maybe that could jog your memory if you need that.
Well, I didn't attempt to settle the child support number, correct?
I'm so sorry, Your Honor. He cut you off.
All right. I didn't attempt to adopt a specific child support number, as I recall.
No, Your Honor.
No, Your Honor.
It was subject to further computation and input into the worksheet.
Yes.
Yes.
So the court's going to overrule the objection to the child support worksheet at this time, pending this court's scrutiny of the eventual worksheet submitted to support the number. All right. Number 9. The court finds that the best record is kept by the Kansas Payment Center of systematic child support payments. I do understand the certain benefit that might accrue to Sydney if payments were made directly to her checking account. However, I think that it's important to keep an official public record of payments made. So I'm going to require that the general provision be followed and that payments may be made through the Kansas Payment Center in accord with what we do in the vast majority of all other cases. All right. Objection 10. Child support will terminate for each child after they complete their high school education pursuant to state statute.
Your Honor, I'm in the process of filing a motion and presenting documents to the court. I really don't feel comfortable proceeding until the court has had a chance to review.
Now we find out what brought us here. A messy backstory. The man was jailed for an incident involving his wife and missed the original divorce hearing while behind bars. Now he's back, still defiant, still convinced he can fix things on his own. It's tragic, almost cinematic. A man clinging to control he's already lost, trying to debate a court that's miles ahead of him.
Okay. Paragraph 35. Isn't that consistent with statutory language, Ms. Schooler?
Yeah, that's what my paragraph 35 says, just more in depth and cites the statute. So I didn't feel like that change would actually hurt the journal entry rather than.
I don't think that there's any inaccuracy there. I see no need for a change. Court will overrule objection number 10. Okay, number 11 does appear to raise a substantive issue here. Petitioner specifically indicates that the respondent was not awarded the 2003 GMC Sierra. Respondent was given a choice. If she wanted the Sierra, then she would have to take responsibility for the debt, or she could be granted the 2003 Chevy Silverado, and that she hadn't indicated her selection.
The Sierra is a business truck that I use on my taxes, and I was awarded everything regarding the business.
The paragraph's not identified, so where is that, Ms. Schooler?
So that is going to be paragraph 38 and 39.
Okay.
And Your Honor, in Exhibit B, the email where I sent the journal entry, parenting plan and child support worksheet to Mr. Wood, I note that there are a couple highlights within the journal entry because I need to be provided the documentation in regards to the Duramax, so my client can make a decision on which vehicle she wants. I have not received that documentation, and there was an objection about it, but I sent it with highlights saying I need this information, it's subject to change. Once I get the documents, I'll let you know her selection. I haven't received those documents, and this objection was filed.
I submitted all that documentation to my counsel. Let me find it.
All right. I don't see that the 2003 GMC Sierra is addressed in either paragraph. Is that what you're... There are a lot of vehicles involved here, but I don't see a specific reference to a 2003 GMC Sierra.
I think she called it a GMC Duramax.
So I believe it's between the Chevy Silverado and then the GMC Duramax are the two options my client can pick. I think there's one in each paragraph for the time being, but when I submitted those to Mr. Wood, there were highlights on them because I don't know where to put each one yet because she hasn't made a decision because she hasn't received the documentation.
Bottom line is, I was awarded all the property in B&B Construction Services, and that vehicle is used for tax purposes. And you have manipulated the court's ruling, Ms. Schooler. The transcript will prove that. In the
All right. So
notice
Ms.
of
Schooler, I trust that the court ordered that she had some sort of choice she could make, and she hasn't made the choice?
Because there's debt tied to one of the vehicles, and you said if you pick this car, you have to take the debt but I need the documentation reflecting the debt, and I don't have that. So she can't decide because maybe it's a significant debt. We don't know.
10,000 and something. I submitted that to my counsel. I got a pile of paperwork here. I'm trying to find it.
Mr. Wood, do you have that documentation as to how much this debt is on the GMC Sierra?
And not other than what I put in there, the amount of $10,024.20. But
Where did you get that?
I'm sure I got it off the documentation, but I can look for that, Your Honor. I just don't know that I have it with me right now, but I can send that to him.
If that's the amount of the debt, what would your client's election be then?
I believe she would want to take the vehicle. Is that correct, Ms. Simon?
Yes.
Even though it has that kind of debt on it?
Yes.
Okay.
But I just obviously would like to do my due diligence and verify the debt amount. So that's why I was not able to make a selection.
What does it say regarding me being awarded property when it comes to B&B Construction Services? Can you state that, Ms. Schooler?
I'm waiting for Chief Judge Ricky.
All right.
That's getting a little off.
I hate to make you resort to this, but apparently Howard State Bank would be the creditor. May take a business record subpoena, but I think Mr. Wood, if he's got it, he'll turn it over, and the court will so direct whether he's allowed to withdraw at the end of this hearing or not. It's just a document in his possession that I believe should be turned over.
I'll look for it, Your Honor, and see if I can find it. If I have it, I'll send it to Ms. Schooler.
That's a very specific number that you stated, Mr. Wood, so I trust that you had some documentation supporting that very specific number.
I guess we could put in the journal entry that, I mean, she'll take that contingent on the debt being that amount, and or we'll get the records.
Not to exceed that amount. Yeah.
Yeah, not to exceed that amount.
Yeah. Mm-hmm.
Will the court take notice that Mr. Woods filed a fraudulent claim for his motion to withdraw? And I'm going to prove it. I have audio and a transcript of it.
Well,
Here comes the outburst. The man jumps in, waving receipts and grievances, claiming his lawyer ignored their child being bitten by a dog. It's raw, unfiltered frustration, but also a total derailment of the court's purpose. You can sense the judge's patience thinning as the man mixes emotional pain with legal confusion, turning this courtroom into a personal battlefield.
okay, why don't you include the legal descriptions?
Because I was awarded 3 properties.
Your Honor, he stated that they were provided to me. They weren't. That was going to require me to probably pay to have to get some more records. My clients' names aren't even on any of the properties, so really nothing's going to be changing. I just didn't add them because I didn't have that documentation readily available.
Okay. So he's already the titled owner on Cliff Street and 501 Line Road in Severy?
Yes, Your Honor.
And your client has no interests?
Nope.
Okay.
We just
And
put
then
it
he's
in there to make
awarded
sure all
the
bases.
Turkey Road property, and you did include the legal.
I did, Your Honor.
All right. Since I don't think it's going to necessarily change anything, I'm inclined to agree that I think we can, if you don't have them to insert.
And if he can provide them to me, I'm more than happy to add them, but it was going to require me to pay, my client have to pay to remedy his objection, and I don't feel like that's proper.
All right.
And it says here,
Paragraph
the court
46.
finds the paragraphs were gifted $40,000. You said yourself that the court acknowledges my grandfather gifted that to me. And then
Okay, we're on the objection to paragraph 46 currently. What's the objection there? That's a standard.
that's what I'm saying, Your Honor. I'm getting ready to provide the court all my objections and how they were manipulated, and a lot of them not objected to when they clearly.
I see nothing wrong with paragraph 46. I'm going to continue to have that included in the decree. Paragraph 16, child support worksheet. I know there's some dispute about whether the court's imputed income numbers However,
We skipped paragraph 48 that I have objections to that weren't submitted.
all right, just a moment. 16. Again, Ms. Schooler, I'm going to reserve ultimate judgment on the propriety of the child support amount based on the court scrutiny of your worksheet, which I don't have. So at this point, I cannot make a final ruling regarding 16. I trust that you have provided documentation of the child care costs.
I know my client testified to it. I believe I did, but if not, I can absolutely submit it.
All right, please do. 17. Object to the permanent parenting plan. Joint legal custody should more specific.
And I
Okay,
did make that correction.
all right, fine.
She
17
submitted
is
Rule
settled.
170 that I was misguided from my client on, or my attorney on. My attorney told me that he needed my objections to this journal entry. And they let Rule 170 slide right past me. And she stated in Rule 170, I believe that the respondent was granted sole legal custody.
That's consistent with the court's ruling.
Look at Rule 170 compared to what the journal entry.
I don't know what you're talking about, Mr. Presbill. So,
I'll lay it out for you.
all right. I think the court has ruled on Mr. Wood's objections.
The judge steps in firm, precise, unshaken. As he methodically overrules objections, the man keeps interrupting until the judge drops the hammer. One more word, and you're muted. That's the sound of authority taking back control. It's a masterclass in courtroom composure. Calm, commanding, and just intimidating enough to silence chaos. Order restored, at least for now.
Ms. Cooler, there's some minor modifications that need to be made to the decree before being submitted.
Can we address paragraph 48 for a minute?
All right. What would be wrong with neither party shall post sexually suggestive photographs or videos on social media or the internet? What's wrong with that?
Nothing, because I didn't object to it.
I thought you just said you wanted to address paragraph 48.
I'm on the journal entry of judgment and decree of divorce.
That's what I'm looking at.
Okay, maybe I had some paperwork. 44, I'm sorry. I stapled my papers wrong.
It's an award, making certain findings.
It states in there, F, respondent shall receive no less than $11,000 with their accrued judgment interest and up to 1/2 of the total proceeds of the sale of the real property. I feel like the wording has been manipulated there to override your ruling. You said that I was awarded the property and that I had until August 31st to pay that $11,000. And I'm willing to pay it in full once this journal entry is finalized.
Okay, so what's the problem if you intend to pay it off?
Ruling.
Excuse me.
Because the wording in there, her wording in there says that the client is still entitled to half the price of the property.
No, it's either or. If you pay it off, 11,000 plus interest by the August 31 deadline, then there's no purpose at that point to the language regarding sale, because a sale wouldn't be necessary at that point.
What's keeping if you retire in a couple years, what's keeping them from bringing this journal entry before another judge that didn't make that judgment and has no idea what's going on? They just have this wording to go by. This wording in paragraph F states that the respondent gets $11,000 and half the price of the property.
Your Honor, what I think I would help is if I indent DEFG so it shows that it's falling under the August 31st to discharge the lien, because D says if he fails to do so, I can indent it so it shows what happens if that August 31st deadline is not met. I think that would make it a little more clear. I don't mind doing that.
It wouldn't hurt if you'll make that change.
Absolutely.
So there's two options there. By August 31, he can pay $11,000 plus accrued interest and buy her out. He can do whatever he wants with his property at
Clarify
that
to
point.
me,
But if he doesn't pay it off by that date, then it goes to the sale provision.
or buy her out. What do you mean by that?
I think
You
the wording is
stated-
fairly obvious.
This moment shows the complexity beneath the drama. A heated dispute breaks out over child support worksheets, numbers, forms, imputed income. The father argues emotion. The judge speaks law. It's the perfect display of how legal reality crushes wishful thinking. Facts, not feelings, rule here. You can feel the air tighten as the defense falters under precision questioning.
You stated that I give her $11,000 and I'm awarded the property.
Plus interest. Yes, that's correct. If you get it done by August 31st.
Yeah, okay.
Correct. Okay. So the real question that remains before this court is Mr. Wood's involvement in the finalization of this journal entry. This court's point of view at this juncture would be that I think it's a professional responsibility that was previously imposed on this lawyer to sign off on what this court believes to be an accurate reflection of the court's rulings. Ms. Schooler, I trust you can address this relatively quickly.
Yes, Your Honor, I'll do it right now. The only reason for my objecting was I need that documentation, and based off of Mr. Perez-Beal's email, I don't think it would be best for me to have direct.
Here's something else that I'm going to ask you to
I
add.
want to wait until we have the transcript.
All right. Ms. Schooler, I want you to add a paragraph at the end of this journal entry that says that effective upon the filing of this journal entry and decree of divorce, Ronald P. Wood is withdrawn as counsel for the petitioner. But I do want Mr. Wood's signature on the document. It does not require, in this instance, Ms. Schooler, the signature of either one of the parties. So take
How
that
can
off.
you say that?
The journal entry is just meant to be a reflection of the rulings of the court. The attorneys have the authority to sign off on that. And the parties themselves just slow up the process. So
This is our divorce, and I'm not agreeing. That's
Ms.
a contract, and I have to agree to it.
Can you give me some realistic appraisal as to when you can get this to Mr. Wood?
I will work on it right now, Your Honor. I can probably have
Today,
it to
then?
in about 30 minutes.
Because I would love to have this in my signature queue by tomorrow.
I will have it to him in
Today,
30 to 45 minutes. I just want clarification. Am I removing the party signature lines from the parenting plan as well?
You are. Oh, yes. Because that's
Okay.
a
Is that legal?
parenting plan and not an agreed upon parenting plan.
Yes, Your Honor.
Is that
Yes.
legal,
Yes.
Your
And,
Honor?
and your child support worksheet will need to require this court's specific approval.
Yes, Your Honor.
Okay.
Your Honor, can you
So that'll be
legally do
submitted in the
that?
queue for separate approval, but along with the decree. Any questions
will-
about that, Ms. Schooler?
No, Your Honor, I will have it to him shortly.
Okay. And then, Mr. Wood, if the journal entry that upon your approval of the wording that I think the court has settled today, when you put your signature on it, that and allowing you to withdraw as soon as the court approves thereafter, are you satisfied with that resolution?
Yes, Your Honor.
All right.
You just said that Mr. Wood, no attorney's signature has to be on that journal entry.
No, I say yours doesn't have to be on there. Nor does Sydney Simons. All
Well,
right.
let it be on the record that I'm firing him. He don't represent me.
It all peaks here. The father accuses his own lawyer of extortion. claiming a $7,000 demand, and the room freezes. But the judge doesn't take the bait. Instead, he slices through the noise, pulling everyone back to the facts. The chaos fades as authority wins again. And that's a wrap on this wild courtroom ride. If you enjoyed watching this meltdown unfold, don't forget to like the video, subscribe to the channel, and we'll see you in the next one.
Court's already made its ruling. He's responsible for signing off as counsel of record as to what happened at the time of trial. Then he'll be allowed to withdraw at that juncture.
How does the court respond to him not? He didn't, Your Honor. A lot of my objections were manipulated
Well,
to make my objections sound stupid and invalid.
if you believe that you should have appropriate legal remedies in this case, following the finalization of this decree, I suggest that you get legal advice from a new attorney and follow that attorney's advice.
Are you going to
That would be
take
my
any
suggestion.
disciplinary actions into him filing a false motion to withdraw?
I don't know how you can call his motion withdrawal false.
Because I'm going to supply with the court a transcript and then audio of him trying to extort money from me and saying that if you don't pay, I'm going to have to withdraw, and then turning around and filing it for what he did.
All
Your Honor,
right.
I said in the motion to withdraw that we had a difference of opinion in the matter, and we do still have a difference of opinion. And as far as appropriate course of action going forward, we disagree on that also. Those are the reasons.
Yes,
Your
which
Honor,
are legitimate reasons to seek withdrawal.
Mr. Woods, what are you going to say when you find yourself in court having to testify to our phone conversation?
All right. Well,
It
we're not
is
going to
what
get
it
into
is.
that. All right, Ms. Schooler, I think you have all the direction from the court that's necessary to finalize the journal entry and decree of divorce and child support worksheet. Is that correct?
Yes.
Your Honor, are you just going to overlook that Miss Schooler had a witness lie on the stand in your courtroom?
That is not an issue before the court at this time.
It is. I objected to it, but it was not submitted.
All right. The court's rulings made from the bench in Elk County stand with the clarification orders made by the court on the wording of the journal entry and decree of divorce. So I think, counsel, that essentially addresses the issues that need to be addressed. And therefore, at this time, this proceeding is currently in recess. I will look forward, Ms. Schooler, to receiving the journal entry, decree of divorce, and new child support worksheet and parenting plan here shortly, perhaps even today. Greatly
It'll be in
appreciated.
Mr. Wood's hands after 45 minutes, so just
All
don't
right.
hold that over me.
Let's get this wrapped up as soon as possible.
Okay.
Thank you, Your Honor.